The 14th Amendment and the Equal Protection Clause were clearly meant to protect freed slaves. But its language is not limited to them. It is much more expansive, declaring that no state shall deny to any person the equal protection of the laws. This seems to suggest that laws can never discriminate against anyone. But laws discriminate against people all the time. We discriminate on the basis of age. You can't get a driver's license if you're under 16, and you can't drink alcohol if you're under 21. We discriminate on the basis of income. People with higher incomes are taxed at higher rates than people with lower incomes. In fact, many laws treat some people differently than others. So the Supreme Court has repeatedly confronted the question of which kinds of discrimination are permitted under the 14th Amendment, and which kinds are not. In 1886, the court decided Yick Wo v. Hopkins. At the time, Chinese immigrants owned most of the laundries in San Francisco. The city passed an ordinance requiring that all laundries in wooden buildings obtain a permit from the Board of Supervisors. More than 200 Chinese owners applied for a permit. The board only granted one. At the same time, the board approved 79 out of 80 permits for laundries that were not owned by Chinese immigrants. A Chinese laundry operator named Yick Wo sued. The Supreme Court unanimously agreed with him that while the ordinance itself was not unconstitutional, its unequal enforcement was. It said, the conclusion cannot be resisted that no reason for it exists except hostility to the race and nationality to which the petitioners belong, and which, in the eye of the law, is not justified. In doing so, the court said that the Equal Protection Clause is not confined to African Americans. It specifically said that it extends even to non-citizens, and it clearly implied that public discrimination against members of any race, not just against African Americans, is unconstitutional. Over time, the Supreme Court has decided several cases that have further clarified the extent of the Equal Protection Clause. In short, the court has decided that some groups are fully protected, but that most are not. The court now uses the term suspect class to describe a group that is protected by the Equal Protection Clause. Which groups are suspect classes, and which are not? The short and simple answer to that question is that any group that can convince at least 5 Supreme Court justices to declare them a suspect class, is a suspect class. The longer answer is that the Supreme Court has developed a specific definition of a suspect class. A suspect class is any group that has suffered from a history of discrimination that possesses the following characteristics. First, the members of the group must constitute a discrete and insular minority. While the court's definition of this term has never been fully clear, it suggests that the group must in some way be identifiable as a member of a group that is distinct from the rest of society. Second, the group members must possess an immutable characteristic determined solely by the accident of birth. In other words, the group must possess a trait that is unchangeable and has been present since birth. Finally, the group must have a history of political powerlessness. The court insists on political powerlessness because the strong can take care of themselves. Only the weak need the court's protection. Over time, the court has applied this definition to several groups, but in most cases, it has decided not to extend the meaning of the Equal Protection Clause. As we have seen in the Yick Wo case, the court has declared that it fully protects people against racial discrimination, and against discrimination based on whether someone is a citizen. This is called alienage. It also protects against discrimination based on national origin. In addition, due to the First Amendment's guarantee of free exercise of religion, the court has also said that religious discrimination is a suspect classification. All laws that discriminate against suspect classes are analyzed using the strict scrutiny test, meaning that the government must demonstrate a compelling interest, and it must use means that are narrowly tailored to achieve that interest. But other than race, religion, alienage, and national origin discrimination, the court has not declared any other groups to be suspect classes. Gender discrimination is not a suspect class. Nor is discrimination based on sexual orientation, gender identity, disability, age, or anything else. In other words, while the Constitution prohibits governmental discrimination based on race, religion, alienage, or national origin, It does not prohibit governmental discrimination based on gender, LGBTQ status, disability, or on any other basis. Laws that discriminate against those groups merely need to meet the rational basis test. However, that doesn't mean those groups are unprotected, as we will see in future videos.